Good afternoon, everyone. Thank you for joining us today. You are currently in the Lunch and Learn session on intellectual property fundamentals and USPTO, U.S. Patent and Trademark Office resources. We will be starting shortly at 12:03. I just want to give a few minutes to let everyone join us.
All right. Okay. Hello?
So, I'm not sure whose mic that is, but if you can please check to make sure that if you are not a presenter, that you're muted. I muted everyone, but I'm not sure if that took effect. But it is 12:03. So once again, thank you everybody for joining us here at the Lunch and Learn on intellectual property and intellectual property fundamentals and USPTO resources. My name is Aziza Muzamil. I'm a business development specialist here at the Department of Small and Local Business Development with the Business Opportunities Division. Please note that this training is being recorded and will be sent out in the coming days once the recording has been transitioned into a YouTube video. Additionally, please make sure to put all your questions in the chat and we will answer them during the Q&A portion at the end of the training. Though Director Rosemary Triggs Evans could not join us here today, she does send her greetings and her commitment to fostering the growth of the small business community in the district through opportunities and trainings like today's. I did want to emphasize the mission of DSLBD, which is to support the development, economic growth, and retention of district-based businesses and promote economic development throughout the district's commercial corridors. Additionally, I wanted to remind everyone here that we do offer technical assistance on multiple platforms. We have in-person technical assistance at the MLK Library in downtown DC. It's called Small Businesses. You can Google it, Small Businesses DSLBD. We cover most of our divisions here at DSLBD are there on Wednesdays. The Business Opportunities Division is there on the fourth Wednesday, so we will be there tomorrow. I will also drop a link in the chat if you are interested in booking a time. Additionally, the Business Opportunities Division does offer virtual technical assistance, which I will also drop in the chat in a moment. Um, Moving on, for today's training, we have partnered with the U.S. Patent and Trademark Office to bring you this vital information on intellectual property fundamentals and their resources. I would like to introduce Gautam Ubale from the U.S. Patent and Trademark Office, who will be presenting on our topic today. Thank you so much, Gautam, for being here today and presenting this important information. I am going to stop sharing here and you can take the presentation on from here.
Hello, everyone. Good morning, good afternoon. I am Gautam Ubale. I'm a primary patent examiner at the office here. I'm also an outreach coordinator in the East, serving the Eastern Regional Outreach Office here. I primarily examine patents in business method, which includes basically anything related to advertisement, incentives, couponing, electronic shopping, e-commerce. We talk about it. And so the idea behind this presentation is to give you an understanding of why intellectual property fundamentals are so important. Hope you guys can hear me clearly, right?
Yeah.
Okay, perfect. So this is just a simple disclaimer. The provided content is for informational purposes only and should not be considered as a legal advice. It is crucial to seek advice or guidance from any relevant authorities to ensure that legal validity and accurate advice on these issues. Um, and so our discussion topic for today is IP is a business strategy and what is intellectual property and the resources. So does intellectual property have a value that can influence investors' sentiment? In my opinion, the IP strategy of a company serves as a crucial indicator of success in R&D and intensive research industries. It also reveals the company's ambition, vision, ability to capitalize on its research and development efforts. So companies can basically focus on IP, which is intellectual property, to basically leverage their resources, basically. Before I say this, if you guys have any questions, please feel free to put it in chat. Or if you need to be answered immediately, you can unmute and ask the question. I'll try my best to answer at that point of time, but I would hold on to the questions to the end of the presentation. That would be great. But so here are some key points to help you develop a winning strategy as an entrepreneur or a small business owner, right? So how many of you guys know about CNBC's Shark Tank program? You can put it in chat or whatever, but I'm guessing most of you guys have seen that show. And the first question any of these guys would ask is basically, if you have any intellectual property rights, or have you filed for any patents or trademarks? Do you have any copyrights? That would be the first question they would raise. And so when people ask those questions, and let's say like a small business owner or individual who has filed for any of this intellectual property, they have a better start within the Shark Tank's presentation by, shining that, hey, I do own something like this, right? And it gives you a leverage about other people who don't have one. So what is the significance and the advantage of this, right? The patents basically deters others from not having what you have come up with, right? It basically helps you protect your intellectual property for your business, and it also allows you to expand your market opportunities. It also helps you expand your business into new territories. Um, Intellectual property rights are territorial, and it depends on the countries where you have filed your application. So if you are in United States and you filed with the USPTO, which is us, you will be protected within United States. And also you will have the ability to safeguard and uphold your intellectual property here. There is nothing called global patents. So you can basically file your application in different countries to protect wherever you're going to do your business with, basically. So what is intellectual property, right? You see on the left side, you see a property in a house, real estate property that you might own, and then the intellectual property. So the difference is, intellectual property basically encompasses of intangible creation of your intellect. And the main goal of intellectual property is to stimulate the development of wide array of intellectual goods. So individuals and businesses are given property rights for information and creative works they produce, usually for a limited time. So these rights encourage creation by providing some kind of financial incentive and safeguarding your ideas from unauthorized reproduction. So basically, would you see a fence? It's the boundary for your house, and the same way intellectual property is like fencing your idea and not anybody to encroach into that, basically. So what is United States Patent and Trademark Office, right? So USPTO is America's foremost agency who's dedicated to fostering innovation and driving the economic growth while maintaining reliable, predictable, and high quality intellectual property system. So the USPTO accomplishes this by issuing patents, which grants the holder exclusive right to their inventions, and by registering trademarks and service marks for products and services, basically. So United States Patent and Trademark Office is responsible for overseeing and regulating country's patents and trademark system. So its workforce consists of over 13,000 employees, including patent examiners, trademark examining attorneys, administrative judges, and patent judges who play essential roles in evaluating and protecting your intellectual property rights. And again, you can see here, let me see if I can bring the laser pointer. Like there were in fiscal year 2023, there were almost 650,000 patent application filed, and almost, more than half were issued. Same goes with the trademark. There were almost 740,000 approximately trademark applications, and just over a half percentage were registered. And obviously, we are headquartered in Alexandria, Virginia. So just to give a little background of the foundation of intellectual property, right? From the early patent laws to modern trademark protection, the concept of intellectual property has played a crucial role in fostering innovation and protecting creators' rights. As technology continues to advance, the importance of intellectual property rights in various industries become increasingly significant. So this is where the founding fathers, they had a constitutional provision reflecting that protecting intellectual property as a means of encouraging progress and creativity. So the Article 1, Section 8, Clause 8, basically Congress shall have power by granting exclusive right to creators and inventors, and the government incentives to creators and basically innovation that ensures that society continues to benefit from new ideas and advancement, basically. So here are the types of intellectual property. This first is patent. Um, so basically, next is the trademark, copyright, and trade secrets. So patent basically, as I mentioned, will go in depth in next slides. Same with the each intellectual property. We'll go over. Hey, Aziza, quick question. I could hear some buzzing going on the background. Do you know if anybody's unmuted?
I do see, I not to call anyone out, but I think Miss Shakira, I think yours might be, I see you're muted. Um, Let me see, I'm going down the line. Um,
That's fine. Now it's gone. I think it's perfect. But anyways, going back to the presentation here.
Sorry, I think Victory Evolving, I see that is not muted. So Victory Evolving, if you could please mute yourself. I'm gonna try to mute them. Okay,
Thank you
I
very
think I
much,
muted them.
Aziza. Yep.
Mhm.
So, anyways, all of this four different type of intellectual property provides you basically a legal protection for different forms of intangible assets, such as innovation, creative work, brand names, and any confidential information. So moving on to, can anybody find any kind of IP in this device, right? This is an iPhone. We all see it. Most of us have seen it. They have a bunch of trademarks, and you see this Apple logo with the R registration. So when you see this R with the circle, that means they have registered with the United States Patent and Trademark Office. The name iPhone is also registered. The name. Then they have multiple patents. They have patents on data processing, um, antennas, display, glass display, chemical compounds, semiconductors. They also have copyrights on their software codes, ringtones, instruction manuals, trademark, trade secrets. They do have some trade secrets that we are not aware of, because that's why the term trade secret comes into picture, that nobody knows other than a couple of individuals in the um, the uh, corporation. And then there is designs also. So they also have design patterns where um, they have the how they place their buttons and switches, how their cameras are arranged. So there's bunch of IP within this one small device. So let's talk about trade secret first. And as you see here, it's always kept secret, right? Um, so here are the two simple product. A trade secret basically refers to a confidential information that holds value due to its unknown nature, right? So an example of this is closely guarded ingredient recipe of Coca-Cola, which is known only to select few individuals at the company level. Um, there's their secrecy adds value to the Coca-Cola's brand, which because nobody else could replicate it, right? Similarly, the soft drink like Pepsi or Cola has slightly different taste compared to Coke. So that's how Coke has kept their formulas trade secret to add that uniqueness within it. Same goes with KFC here. So KFC also has their renowned secret blend of herbs and spices for the chicken. And they have also kept this trade secret and were able to differentiate their product from other fried chicken, basically. Again, trade secret can also include something as simple yet as valuable as company's client list, which is also kept confidential. And again, Google, right? So the search algorithm for Google is also a trade secret. So whatever you Google, that whole algorithm is basically a trade secret. So why use a trade secret? Correct. So trade secret, again, we talked about it. The trade secrets are maintained and are within the company confines and are generally protected by signed agreement between the employees and companies. These contracts may require non-disclosure of proprietary information and non-competition after an employee leaves, This falls within the level of reasonable effort to maintain secrecy and keep information out of public domain, basically. So how the common ways to lose trade secret would be to avoid happening that the best way is to regularly conduct audits to identify and address potential vulnerabilities that can help prevent reverse engineering or any unauthorized disclosure. Also, the Defend Trade Secret Act of 2016 empowers trade secret owners to file lawsuit in federal court in case of misappropriation. So, for instance, if a former employee departs and discloses your trade secret to a competitor, this act provides a legal recourse to protect your intellectual property. So far, any questions related to trade secret? Um, if not, I'm gonna move on to the next topic, copyrights.
Hi.
Yep. Hey.
Yeah, I'm Simeon Chama. Thank you for giving us this information. I have two questions. First of all,
Sure.
do you think that as a human, thinking, doing research, working hard, people can know write the same code similar to some code in the trade secret? Because I can do my independent research in another country without even be aware of what is going on and get the same result. Is that infringement to the trade secret or to the copyrights, stuff like that?
So,
How can I prove that I did not copy anything from somewhere else?
so it's a
And the
very
second question was that what will you recommend between all this information for a new business just creating? Which is the best one to do? That's my second question. Thank you.
um thanks. A very great question, and it's tricky to answer, but I can at least um so trade secret, if let's say you let me rephrase it. You're asking that if you and a person B has created same kind of for the software code and they spit out the same result, how do you know you can protect each other, right? Basically, or is anybody infringing on each other? So the idea of trade secret is basically you're keeping it secret. So nobody knows it until you can really prove it that that person has really kind of copied your code and got the similar result. So it's very difficult to identify that in terms of that other than um, somebody has misappropriated, just like I mentioned about it. um, Second question that you have is what was the best route to go? So this is where I think you as a individual or a company, you have to do the research to see, is it worth for me to file for a patent or a copyright, or should I just keep secret based on what value I'm going to gain out of it. So it's purely it's based on the individual and the company. I and technically I can give you an advice on this, as I mentioned in earlier disclaimer, right? Um, so you could also seek some from some kind of legal authorities, some guidance from them. That would be the other best bet if you really have something. Hope that could answer to the best of your knowledge. So if there's no more questions, I'm gonna move to the copyrights. I think we got 10-15 minutes, but I
Sorry,
wanted to.
Gautam. So
Yep.
we have one question from Michael Brown in the chat. He said, what is the difference in provisional and non-provisional?"
We're gonna get to that. So hold
Okay.
on your thought for that. That's in the patents, and we'll get to that. So let me catch up with the copyright quickly, and I think we're gonna jump to trademark after this and patents at the end. So, but great question so far. Um, So when it comes to copyright, it gives you a legal protection for original work of authorship as soon as an author fixes the work in a tangible form of expression. So this encompasses a wide range of creative endeavors that includes songs, movies, books, sculptures, paintings, and architecture, among them others. So it is important to note that the copyright protection only applies once the idea is affixed to a tangible medium. So that's very critical in here. So Copyright Office is a part of a Library of Congress. Additionally, they under the Secretary of Commerce for Intellectual Property, also as an oversight authority on the copyrights. The term of a copyright is generally a life of author plus 70 years or 95 years from first publication for the works made for hire. So anything you write down like paint, photograph, etc. is copyrighted, but it needs to be protected by registration with the Library of Congress to gain strong protection under the law. And so again, what is copyright, right? We just talked about it. It basically provides what do you call 70 years after the death of author, and if it is an individual copyright owner. Again, if the copyright owner endures for terms of 95 years from the year of its first publication or a term of 120 years from the year of its creation, whichever expires first. So, and they basically include again literary, dramatic, musical, artistic, and certain other intellectual works. So again, here are some examples of copyrightable work, which includes songs, books, sculptures, movies. So you can basically find the copyright notice on the majority of the company's website also, right? When you scroll through the website at the bottom, you will obviously see some legal disclaimer and term of use, and basically that notice plays a crucial role in safeguarding the company's intellectual property and preventing unauthorized use of their content, basically. Slide. Oh. So what works are protected again? So this is where I think I mentioned it a couple of times. It is very important to note that copyright protection extends to both published and unpublished works, as long as they meet the criteria for originality and fixation in a tangible medium of expression. So it has to be fixed in a tangible form of expression. That is very important for that to happen. So next, we're gonna jump into trademarks. Does anybody know what this R symbol mean with the circle or just the TM, the difference between them? If not, we'll go over it anyways. So what is a trademark, right? Trademarks are sometimes more valuable and important than patents since they identify a word, name, service, or a device that is connected to a goods or services and or source of that good or services, basically. So if there was no identifying mark that distinguished products or attributes from one another, we would have a difficult time finding out what we really liked or needed, right? So in case, again, I talked about Coca-Cola. If every soft drink was identified with the word soda or cola on it, how would we identify Coke, Pepsi, or Mountain Dew or from Sprite, right? Same thing, Dr. Pepper or generic non-branded products. So same goes with the drugs, cars, airlines, all other goods and services we expect. So again, most people know many word or name brands and are relatively familiar with symbol marks. As you see here, some of them, basically the bow tie mark for the Chevy cars, the Nike swoosh, those are some device marks. How about colors, right? What companies are associated with pink when you think about it? They are Mary Kay and Owens Corning fiberglass insulation. And the one requirement to get a trademark is that it needs to be specific to specific class of goods and services. So when you think of having a confusion of the color pink between Mary Kay and Owens Corning, the different classes would cause no confusion of goods or services unless you started selling Owen Corning's fiber glass as a makeup for Mary Kay's insulation, basically. So that is where that classification, different classes come into picture. Um, Same with identifying color brown, right? When you see a UPS truck, you know that UPS truck with the individual who delivers is also dressed in a brown attire. So we know that that's UPS truck. So same way we can associate, and they have trademarks on all that and service marks. So what do trademark offer, right? So trademarks offer basically a brand recognition, right? It also offers legal protection and exclusive right to that brand or logo, ensuring that others cannot use it without permission. Additionally, it also provides recognition and differentiate your product or services from competitors in the market. Again, using that R symbol, which you see here with the circle, symbol means that the brand or logo has been officially registered with the relevant authorities, which is the United States Patent and Trademark Office. So this serves to strengthen its legal protection and ownership, providing robust reassurance. So this symbol also serves as a visual cue to consumers that the brand is established and reputable, right? Just like the Apple's logo. You saw that it was registered with our circle on it. So this basically helps protect the company's reputation and ensures that only real products are sold, giving consumers confidence in the brand authenticity, basically. And again, the registration of a trademark serves as a cornerstone for expanding business operations into foreign countries. It is essential from preventing unauthorized use of identical or similar trademarks in different jurisdictions. This is also essential for companies seeking to expand their operation and safeguard their brand on an international scale, basically. And again, you once you register with us and you get the trademark, it's published in US trademark database. So it is searchable on our website. So here are the different types of trademarks. There are several. They include basically word mark. They include composite mark, special form mark. They include design mark. And all these different types of protection can be used to safeguard a brand's identity, basically, right? This basically, when you register with this proper, basically this Coca-Cola, the way it's written, that word mark is registered with trademark office. Again, composite mark, which this red circle with Coca-Cola and always, that's also registered with the patent trademark office. This sign, the shape of the Coca-Cola bottle, they're all registered with us here. Again, so the other examples are also word, slogan, symbol, designs, combination of this product packaging. You means this one is the Tiffany box, which everybody, when they see it, they know it. Again, Owens Corning fiberglass insulation here, the TikTok symbol here. This is the apples. When you walk into the mall and you see this layout, you know this is Apple Store and Hershey's Kisses. And trademark also can be a sound, color, or smell. So any questions so far with trademark?
Yes, a couple questions. So is the trademark symbol, is that used for like pending, the fact that you filed to let people know, number one, and then once you get the registered mark, are you protected from international, or you have to register to use it internationally?
Great question. So first is trademark. When you have the TM sign, uh, it could be that you can use it without registration also, but once you have it in registration and you get the registration, you are able to replace that TM with your R circle symbol, like going forward. So that puts everybody on, you know, kind of on the face that, hey, I am registered, nobody can copy this now anymore. But you, it's only registered if you file in the United States, it's only registered in the United States. To protect yourself in different countries, there is a whole system called Madrid system that helps you allow to designate the countries that you want to do business with. As I mentioned with the patents too, there is nothing called global patents. Same way, you have to register with those countries too.
So
Hope,
follow-up
hope,
question. With the
yes.
Madrid system, is that something to USPTO or is that a different entity?
Um, you know, it's basically it's a tie-up with us, and you can use that system to register and assign, but I'm not too positive because I work on the patent side, but still you should be able to basically file for the application, and I would highly recommend trademarks are so complicated that you should seek some legal advice or, you know, hire somebody in that aspect because of that.
Okay, so it's not associated with the TDAS system?
The you talking about the patent trademark system?
Yes.
Yeah, no, it's not. No.
So I just
Oh,
want to
it's-
make sure we're answering all the questions. If please refrain from using the mic if you put all questions in the chat, just so we can make sure we're answering all questions inputted into the chat. I think one of the first questions, I'm not sure, Gautam, if you answered, was can someone use the TM or SM without registering with USPTO? And do they have
Yes.
the protections without registering?
So they can use it, but it is so how TM and SM will work is, let's say if they are using a product, a service, or goods, whatever, let's say within Virginia, and there is nobody who has that similar goods or services related to that name association, they can only be protected within that state. The advantage of registering gives you the opportunity to expand within all 50 states, basically. So, but again, it comes with doing quite a bit research that nobody is using that same name in different state. And then it comes with the idea of who was first, right? So that it falls under that basically criteria at that point of time.
Okay. And then we have somebody else. We have a few questions. I'm going to try to go through them as quickly as possible. We have somebody said that their trademark registration was opposed and they have hired an attorney and first proposed a coexistent arrangement, which was refused. As a result, they submitted a response to the opposition. What is the approximate timeline for a resolution? And historically, how often is the opposition upheld and enforced?
Well, that's a great question and tough one.
Yeah.
I am not sure about the time frame, but I think I can put the link at the end of the presentation where you can see your pendency rate of how fast the applications have been, you know, resolved. So I think trademarks are within a year, under a year, if I'm not mistaken, but I'm not positive about it. And I think it's great to hire some legal advice from outside if you have some opposition come through. I think the whole idea is giving more clarification on that will help, basically, end of the day.
And then we have somebody says, I'm not sure if you'll get to it later, but asked to discuss the fees to registering and why the process takes so long.
Um, Fees to register. So did you here? I'm gonna put this slide so you get a perspective why it takes so long. I'll answer that quickly. So you see in this slide, right? There are only 756, so 750 trademark examining attorneys. And do you see the volume within a year of almost 740,000 applications? So basically, we are talking per attorney to examine. You have to do a math on that, and so that's why it takes almost close to a year, I think, to get that. That's the idea behind it. Hope that answers that question. Same goes with patent examiners. When you see that too, we have 8,500, 86 almost patent examiners, and you see the applications filed last year itself. You just have to do the math on that.
And then we have somebody says, when should someone apply to renew an existing trademark? How early before it expires? And also, what is the best and easy way to file for a renewal of a trademark?
So if I'm not mistaken, I don't want to give wrong information, but what I remember, because I'm not an expertise in trademark, but I think trademark, when you get a trademark, I think you have to renew in the first one is the 5 year mark, I think, and then after it's every 10 years, you have to renew it. But I can post the link of actual timeline from the website too.
A few more questions. We have Jackson said, under good and services on USPTO search, what's the difference between international and US classes?
I think they are all, we go with the, so I'm not sure about trademark, but I know with the patent system, we went with the, we went away from USPC to CPC, which is what do you call, classification treaty, where everybody throughout globally follows that same CPC classification at this point of time. But trademark, I'm guessing it's similar. I'm not sure if there is two different things right now.
Then we have, can there be a trademark and a copyright for a symbol at the same time?
Yes, you can. And and then the resource section that we will go through, I can basically guide you what we have a tool that will help you basically identify that. Like it's simple, basic 6 questions, but I'll run over in the resources for that. That helps.
Okay. And just I think we have one last question. Somebody said need a copy for materials. For everybody registered for this training, I will be sending a recording of this and also the PowerPoint presentation in a Adobe PDF format. And I think the last question so far is someone has a question that, they've worked in the intellectual property legal field for over 20 years and have the educational credentials and want to become a trademark attorney. Does the USPTO assist people in becoming trademark attorneys? And if so, what steps should she take or should they take?
Well, the question is, do they want to work for US Patent Office as a trademark examiner? The criteria is basically they have to have a law degree, I think.
Okay. And I would suggest to that person to follow up. We will have resources and contact information, so please follow up on that.
Sure.
And that's the questions we have so far. We can move on
Hey,
to
I
the
think
next.
I don't know if I forgot, but there was a question that I posted with regards to the trademark. I don't know if I missed the answer. The question was, when should someone apply to renew an existing trademark? Like, how early can they apply before it expires? That's the first question. The second question is, what is the best and easy way to file for renewal for this is for trademarks, existing trademarks for the first time?
I think I mentioned about it, but I will also post a link to the website. When you get a trademark registered with the patent office, I think for the first 5 years, within that first 5 year, you have to renew it, and then it's every 10 years to renew it. Hope that answers.
Yeah, that's fine. I'll look forward to the link. Thank you.
Yeah, yep. So Here, so we're gonna go jump into patents. I think we have 20 minutes to cover resources. I'm gonna run through the slides. So what is a patent, right? Patent provides you, again, a legal power to prevent others from making, using, or selling your invention within the United States or importing it into country for a period of usually 15 to 20 years in exchange for publicly disclosing the details of your invention. So this gives you an exclusive right to protect your innovative ideas and investment and giving you a competitive edge in the market, basically. Again, there is no such thing called worldwide patent. Um, we same goes with the trademarks too, right? You have to register with those countries individually to get protection wherever you want to do your business with. So there are three main types of patents: utility patent, design patent, and a plant patent. Utility patent, again, protects new and useful processes, machines, composition of matter, or improvement to existing inventions. Design patent covers new, original, and ornamental design for manufactured article. It protects the visual characteristics of an object, ensuring its aesthetic appeal is preserved. Plant patent, on the other hand, protects new variety of asexually reproduced plants. So all of these different types of patent plays crucial role in safeguarding your innovation and creativity. Both utility and plant patent last for 20 years from the date of filing, while design patents are valid for 15 years from date of issuance or grant, basically. And so to obtain a patent, how do you go around, right? You must first conduct a comprehensive search to confirm that your idea is original and has not already been patented. This search will help you determine if your idea is novel and worth pursuing a patent for. So after you finish your search, confirm that your idea is new. The next step is to file for an application, patent application. And this application includes thorough description of your invention, as well as relevant drawings, diagrams, and the claim, which is the basically your deed of your property, basically. So again, when you have an idea that is groundbreaking, securing a patent for your idea is essential because it gives you the edge over others, right? And now with the United States Patent Office, its first inventor to file which is pivotal to safeguarding your right. And it serves your comprehensive resource, providing all answers to your specific patent inquiries. So first to file is so important. And I think somebody raised the question of provisional versus non-provisional, and we're gonna go over that after this few slides, I think. So the main distinction between the provisional and non-provisional application is it's very crucial. So what does the provisional application do, right? It's basically a very cost-effective option that can help you secure the filing date because the United States, again, is the first to file, right? So it will basically help you secure your date. It is also important to note that the provisional application is not published or examined. So simply filing one will not result in an actual patent. However, it does provide a 1-year opportunity to pursue a non-provisional application for your invention, basically. So on the other hand, the non-provisional application goes through the examination by a patent examiner like myself and carries the potential to result in a patent. It is published 18 months after the earliest filing date and must meet specific statutory requirement to secure a patent. So it is crucial to guarantee that the non-provisional application maximizes the filing date of the provisional application by fully supporting the claim subject matter. So again, the main distinction between the two is the provisional is not examined or published. You get a year's time and you can secure your basically filing date. And within the year, you need to file for that non-provisional application. So you can claim that provisional's filing date, basically. Hope that answers the question for somebody who had asked the difference between these two. and we will jump into resources. So I'm gonna close this and I'm gonna open the other slide. So give me a second quickly.
If you don't mind, while you're doing that,
Yes.
we did have one question.
Sure.
Someone said, would you recommend working with the approved law clinics at colleges and universities for assistance with registration of trademark and copyright?
We will go over those resources right now, and maybe after that you still have a question, please, I can circle back with it.
Okay.
So again, I'm just gonna run through these some slides and then jump quickly into resources. So again, USPTO's main idea is to foster innovation and economic growth. It accomplishes this by issuing patents to grant holders exclusive right to their invention and registering their trademarks as service marks for products and services, correct? And then we went over all the types of intellectual property here. I'm gonna get into the USP. So if when you log into USPTO.gov, we offer a variety of resources for all kinds of intellectual property. And also we provide help with applications, education, trainings. We also have resources that will help find attorneys and business advisors. So when you go on this website, you will see um, this page, what you're seeing here. Let me get this laser point. And if you click on this public events initiatives, you should be able, it will have a drop down menu. And maybe if I have time, I'll quickly scroll over and show it to you guys. But you can click on any of these links and it will take you there, what you're looking for. So we have an expanding innovation hub. So this inclusive innovation basically encourages equal access and benefit for everyone. It aims to solve the current obstacle and make it easier for everyone to contribute their diverse perspective and skill to innovation fields. And you can access this web page by clicking on this link here through the PDF. And then USPTO regional offices. So as I mentioned, our headquarters is in Washington, Alexandria, Virginia, and we have 4 satellite offices. One in Detroit here, second one is in Dallas, Texas, third one in Colorado, Denver, and the fourth one is in Silicon Valley in California up here. And then by end of 2025, we're gonna have a South East regional office in Atlanta um, by before end of 2025. It is. So this is another play. When you click on this link, you should be able to see how to get started. What do I need before I apply? All kind of information. There's tons of information in here. But again, some of this information you can reach out to us to, let me see. I think the next page will have IAC, which is Inventor Assistance Center, and they will also help you guide through that. But again, there is a lot of resources for startups. So you could really see, hey, I need some funding. How do I go around it? There are links for this, and you can basically click on it and look into individuals' needs. Again, if you type USPTO video library, you will see a bunch of these videos and presentations related on YouTube. And you can subscribe too. And then this is where I was talking about the Inventor Assistance Center. They offer quite a bit information and services to public, and they consist of former supervisory patent examiners and former primary examiners like myself, who are basically dedicated to assist you and inquire any inquiries regarding patent examination policies, procedures. They are basically there to help you with any form fillings or any questions regarding fees. They can answer all that, but they will not be able to give you legal advice. And same goes with the trademark assistance centers. It's the same similar thing. And then we also have a pro se assistance program, which offers valuable outreach and education to applicants who choose to file patent application without the aid of a registered practitioner. This initiative is designed to empower and support individuals in successfully navigating the patent filing process on their own. Um, and by equipping them with this necessary tool and knowledge, we strive to ensure that this applicant can confidently protect their invention and ideas, basically. And you can basically call them or email them at this email address up here. We also have a network across the country that helps inventors and small businesses with limited funds. The pro bono programs, they will basically offer services for any participant who qualifies under the income 300% below the federal poverty level guidelines. They are basically can take advantage of this pro bono program, basically. And again, this link, if you when you click on it, it will show you the criteria of am I eligible or not based on that in your income levels. And again, we offer complimentary legal aid to support and guide independent inventors and small businesses through the process of preparing and submitting your patent application or trademark application. And our extensive network spans across the entire country. There are volunteer patent professionals with inventors and businesses who have financial limitations. Each regional program serves residents of one or more states. So again, eligibility for all these services is based on income level as the applicant's understanding of patent procedures and their innovative inventions, basically. Again, you could email us here and check with that do you qualify for this. Again, we also have law school clinics. I think somebody raised question on that. We have almost over 60 law school clinics who offer pro bono legal services to public, including inventors, entrepreneurs, and small businesses. These clinics also provide patent or trademark legal assistance to eligible individuals who are accepted as a valued clients. Again, this law school clinic allows students enrolled in participant clinic programs to gain practical experience by representing client before the USPTO under the strict guidance of law school faculty. And again, you have the email address here and the links to look into more depth. And then we have Patent Trademark Resource Center, which is this is one of the amazing network of public and state academic libraries across the country. The whole idea of them is to disseminate valuable patent and trademark information. They also help with many services, like they can give you access to resources, explain application process, fees, demonstrate patent and trademark search tools, offer classes on intellectual property, what similar to us, and they can also help you do searching for you guys if you have any questions. But I would highly advise that if you go to any of this center, call them ahead and make a reservation. And so this basically is we have a reduced patent fees for small entities, which is this is, I think, supposed to be 60%. It's not 50%. It's 60% reduction in most patent fees. Must be an individual or a small business, less than 500 employees, or a nonprofit organization to fall as a small entity. And then the micro entity, basically, there is a 80% reduction in patent fees. So the criteria is to file no more than 4 previous applications and income not greater than 3x median. And not assigned to other micro entity. So those are some criterias. And again, if you click on this link, you should be able to see the criterias for reduced patent fees. And so people who tend to want to register and get their filing date, provisional patent, as I mentioned, their fees are really, I'm guessing under $100. So for $60 or $70, I think you can get your filing date with all the detailed description of your invention, basically. But again, all those are on our website. We also offer the track one prioritized examination that allows you to expedite your examination patent process. It will accelerate of getting your patent approved in a shorter period of time and sooner. Again, there's a link below here. And then again, we also have a first-time filer expedite examination pilot program. This by this CI2 basically program aims to empower inventors and fostering innovation and economic growth in more inclusive way by offering them guidance. This pilot program also streamlines the application process and make it more efficient and user friendly for. Then we have women's entrepreneurship program. As the US Patent Office had seen a significant increase in women's entrepreneurship in recent years. So this trend is a positive indication of growing influence of contribution of women in business world, basically. And then this is the tool that I was talking about is the new IP identifier tool. It's on our main website. When you click on it, there is basic IP identifier. It has only 6 brief questions, and it will let you know at the end of the day that what should I do? Can I copyright, patent, trademark, design? Maybe you can do all 4. So it based on answering those questions appropriately. And then we also have this USPTO resources helpline number that you can call during the hours of, I think, 9 to 8 something. And then you have all these links here. And then we have obviously free USPTO events. And I can quickly glance, quickly open and show you what it looks like. Can see my screen. So this is what the page when you log in, you'll see it. And if you click on identify what kind of IP you have, this is where you go and select and you can identify what intellectual property you possess. And you click on public events or any upcoming events here, you'll see all kind of events that we offer, which is all free, and it will all to say it's virtual or whatnot. And that's one of it. And then again, you can go on patent basics, USPT in your region, access our free resources, which I think is a great resource. If you click on it, and let's say you want just the patent related, click on patents, it is going to show you everything that you need here. Hope this helps you guys. But is there any more question? I know we passed a lot of our time, but I can take some questions if anybody has some.
Question from Sylvester. They said, can you talk about the, sorry, Sylvester, is there a reason that there are not reduced filing fees for trademarks?
So I'm not sure, but trademark per classification is $250. And if you want patent of trademark examiners to do the searching and everything without classifying, I think the fees are $350. But I'm not sure if they have reduced fees for that I'm aware of, because I don't deal with trademarks that much.
So Sylvester said, can you talk about the fraud emails / calls after you file and how to avoid them?
That's the simple answer.
I'm sorry, hello? Or is there like is there a specific like domain that they should look for to make sure that, you know, they are communicating with the correct entity? I think it's at USPTO, or what should they be looking out for to make sure that, you know?
Oh, in that terms, you should be, if you're in USPTO.gov website, like the one I showed here, right? You want to make sure that when you click on it, you should see this .gov, and it is not something different, like, .ru or .in or something, because then you're not on a official website of USPTO. I would avoid clicking on any links that you're not sure of.
And yeah,
Can I
same
elaborate on it a
as.
little bit? Once you file, you're in a public database and everybody, and they know that you filed. So you get tons of emails, calls, identifying, saying they can do this, they can do that, et cetera, et cetera. So,
Right. Well, I think those are all marketing emails, right? It's like when you're on Amazon, you're looking for a product, you find something, and then next you see is they're trying to push on all kind of related product or complementary product related to that. So it's very similar. You just have to do due diligence of yourself. What do I need to look for, basically?
That's all the questions we have so far. If you have any remaining questions, please put them in the chat.
And if after this presentation is over and you still have a lot of questions, please don't hesitate to email us at, I think at this email address here, Eastern Regional Outreach Office at USPTO.gov. And this should be on the PDF file. Ask questions, we will get, like, anything related to trademark copyright that I'm not expertise on, we can get the right answers also. But somebody asked me about trademark maintenance, right? So I think you can type here trademark maintenance. I'm just gonna see.
If possible, can you put that email that you just mentioned in the chat?
Yes, I can do that. I think if you click on it and they should have maintenance fees. Or you can
I'm not
just.
sure. You're not sharing your screen, so.
Oh, am I?
you're not-
Oh, I'm
it's-
so sorry.
no.
Let me see. Let me share it. Share my screen quickly. So I think this is the section trademark timelines. So if you can click on here, and here is the trademark dashboard that you can see the pendency and quality. You could technically type it in, when, let's say, like if you type in trademark maintenance timeline, it will come and make sure that this has a .gov. So that's where you're getting, and I think it's here also keeping your registration alive. If you click on it, this will, it did mention that every 10 years. So between the 5th and the 6th year after your, so yeah, the first time when you do it, it's between the 5th and 6th, and then you have to do between 9th and 10th, and then every 10 years for going forward, which is mentioned during the presentation. Hope that answers the question for some of you folks.
Thank you so much, Gautam. I think that's all the questions we have. And everybody, thank you so much for joining us here today. I know we went over a little bit, but as you can see, it was worth it to make sure you guys get all the information that Gautam has presented. Again, this was recorded, so we will be transferring this to a YouTube video, and you will receive the link to this recording, as well as the PowerPoint presentation used in this presentation by the end of the week. Thank you so much again, and you all have a good afternoon. Bye-bye.
Good afternoon, everybody. Talk to you guys. Bye.